All right, everyone, welcome back to the deep dive. Today we are plunging into, well, quite a fundamental but often tricky area of criminal law.
Non-fatal offenses against the person.
Exactly. It's absolutely crucial stuff for understanding how the law protects people from, you know, harm and unwanted interference.
It's definitely a core subject,
Yeah.
full of really specific definitions and, well, a lot of important case law. Getting a handle on it really helps unlock a lot of criminal law concepts.
Absolutely. And for this deep dive, we're really lucky to be drawing on materials that have been generously made available for educational purposes by the University of London.
Yeah, that's fantastic.
We definitely want to give them full credit for making such a valuable resource accessible to students everywhere. It's just a brilliant foundation for learning this topic.
It truly is. We're always grateful for resources like these that support legal education. It makes a huge difference.
And this deep dive is brought to you by Sinorbit Academy, Sri Lanka. They're dedicated to supporting your learning journey wherever you are with it. And, to all of you listening who might be studying this very topic right now, maybe even getting ready for exams,
Yeah, good luck.
the very best of luck. We really hope this conversation helps clarify some of these ideas and, makes them stick a bit better.
That's definitely the aim, to help you kind of cut through the detail and really grasp the essentials.
So, our mission today, unpack this material, break down the key offenses, get clear on the sometimes subtle differences between them.
And then really dive into the role of consent, which is, well, it gets complicated. How it plays a part or sometimes doesn't play a part at all.
Exactly. When it's a defense and when it just isn't.
You can think of it like climbing a ladder of seriousness, but you also need to understand those foundational rungs first.
Okay, then let's unpack this. So the source materials start by giving us a really useful high-level split for these non-fatal offenses. They say they fall into two main forms.
That's right. You've got crimes of violence on one hand and crimes against autonomy on the other. It's a really key distinction based on what the law is trying to protect.
Okay, so crimes of violence. That sounds like it's all about physical injury, right?
Precisely. The main focus there is squarely on causing physical harm. So if you can't actually prove harm occurred, you generally can't make out one of these offenses.
All right.
And here's a really crucial point. For these crimes of violence, where harm is caused deliberately, consent is generally not a defense.
Ah, okay. Because the state basically steps in and says, look, causing significant physical harm to someone is just wrong in itself, regardless of whether they agreed to it.
Exactly. With very limited exceptions, like, properly conducted surgery. It's seen as being against the public interest to allow people to deliberately harm each other.
Okay, so crimes of violence focus on the result, the harm. What about the other category then? Crimes against autonomy. Autonomy meaning like personal freedom.
Yeah, your freedom to control your own body and actions. These are fundamentally different. The focus isn't necessarily on whether harm was caused. It's about undesired interference with your freedom of action. The absolute core of the offense is the lack of consent to the contact or the threat of contact, not whether you actually ended up getting hurt.
Ah, I see the difference now. So the source gives that example of a non-consensual kiss. If someone kisses you without you agreeing,
Right.
that's potentially an offense because they interfered with your bodily autonomy, even if it caused zero physical harm.
Exactly. Now contrast that with, say, a consensual fight where someone gets a broken nose. The consent to the fight doesn't stop it being an offense if that level of harm occurs.
Because then you're back in the realm of crimes of violence, where consent to deliberate harm usually isn't allowed.
Precisely. You've moved up the scale. So it's all about what the law is protecting, physical safety in crimes of violence, versus your right to decide who touches you or makes you afraid of being touched in crimes against autonomy.
Got it. So let's drill down on crimes against autonomy first. And the big one here, the foundational offense, is common assault. But it's actually two things, isn't it?
Yes, it's really critical to remember this. Common assault is the umbrella term, the label for two separate offenses, what we properly call assault and battery.
And the source materials use helpful terms like psychic assault or simple assault for assault proper,
Yeah, those are good descriptors.
and physical assault or assault by beating for battery.
Those terms really do nail the difference. Battery is the physical one. It involves the unconsented to application of force. Hitting someone, pushing them, spitting, even just unwanted touching.
Okay. And assault, the psychic or simple one, that's the unconsummated threat of force, making someone think they're about to be hit.
That's it, exactly. They often happen together. Of course, you threaten someone, assault, then you hit them, battery. But they can definitely happen on their own.
Like a threat without the hit or hitting someone from behind who never saw it coming.
Right. Assault only in the first case, battery only in the second.
And the source gives a really important practical warning here, drawing from cases like R. Cratcher v. Leicester Magistrates Court. You have to charge the right one.
Absolutely. If you charge assault when only battery occurred, or vice versa, the case can get thrown out. It just highlights how vital it is to distinguish them properly. R. Cratcher v. Leicester Magistrates Court. Remember that one?
And these two, assault and battery, they're offenses in their own right, but they're also like the basic building blocks for more serious offenses further up the ladder.
Completely. They're the essential ingredients for something like Section 47 ABH, which we'll get to.
Okay. And they started as common law offenses, right? Developed through cases.
Yes, but now they have a statutory basis. Section 39 of the Criminal Justice Act, 1988, puts them on the statute books. But you still absolutely need the case law to understand the principles. It draws from criminal law and tort law, like trespass to the person.
And they're summary-only offenses. Tried in the magistrate's court, maximum 6 months.
That's right. Okay, let's focus on assault first. The psychic assault. The source gives us that classic definition from the case of Venna. It's worth repeating. A person is guilty of assault if he intentionally or recklessly leads someone to apprehend the application to his body of immediate unlawful force.
Let's repeat that. Intentionally or recklessly lead someone to apprehend the application to his body of immediate unlawful force. Okay, so the actus reus is causing the victim to apprehend immediate unlawful force. What does apprehend mean here? Is it just being scared?
Not necessarily scared, although that's often the case. Apprehend basically means expect. The victim anticipates that force is about to be applied to them. Cases like Savage and Parmenter confirm this focus on the victim apprehending, expecting immediate unlawful force. Remember Savage and Parmenter.
Okay, expect. And the definition uses the word immediate. Now, this is where things get really interesting, because the law seems to have shifted a bit on this.
It really has. Traditionally, immediate meant pretty much right then and there, face to face. A threat of future violence wasn't enough. That was Halliday.
Right.
And if the threat couldn't actually be carried out immediately, like in Thomas v. NUM, where striking minors were threatening workers in police-protected vehicles, well, no assault, because there was no prospect of immediate violence. Repeat Thomas v. NUM.
But that's changed now. The source highlights a relaxation of this immediacy rule.
Yes, significantly. The focus has shifted away from whether the threat could be carried out that very second towards the effect the threat has on the victim's mind. Does it make them apprehend force in the very near future?
And the key case showing this shift was Smith v. Chief Constable of Woking.
That's the one. Remember Smith v. Chief Constable of Woking? This involves someone peering through a woman's curtains late at night. He was outside, she was inside.
So physically separate.
Right. But his actions terrified her, made her think he was about to come in. The court said even though he was outside, his behavior created a fear of potential violence that was, in the court's words, sufficiently immediate. They noted that terror often makes it hard to analyze exactly what you fear will happen next, just that something bad feels imminent.
That case really paved the way for Ireland, didn't it? A huge House of Lords decision.
Ireland is massive here. Repeat Ireland. It dealt with silent phone calls and also threatening calls. The House of Lords confirmed two big things. First, you can commit an assault without words. Those silent calls creating fear were enough.
Wow, a silent call can be an assault.
Yes. And second, crucially, you can commit assault without being face-to-face. The threat over the phone was enough if it led the victim to expect immediate personal violence.
And Ireland also settled the point that words alone can be an assault.
It did. A purely verbal threat can suffice. And then the Court of Appeal in Constanza took it even further. Remember Constanza? They held that even threatening letters could constitute an assault if they caused a fear of violence at some time, not excluding the immediate future.
Not excluding the immediate future. That really does sound like a relaxation of the old rule.
It's a considerable relaxation, yes. The effect of Ireland and Constanza is that immediacy is now interpreted much more broadly, focusing on the victim's apprehension of imminent harm.
Okay. The actus reus also requires the apprehended force to be unlawful. Makes sense.
Yes. If the defendant is acting lawfully, like in self-defense, it's not an assault. The case of Cousins established that even a threat to kill could potentially be a lawful self-defense. Repeat Cousins.
Or if it's, say, reasonable force used in a lawful arrest under Section 3(1) of the Criminal Law Act, 1967.
Exactly. Or, and this is key for crimes against autonomy, if the victim consents to the approach or potential contact, like the circus knife thrower example, the volunteer consents. So, no assault.
Right. Now, the mens rea for assault, you said the definition mentioned intentionally or recklessly.
That's right. Intention or common law recklessness. And that means the defendant must intend to cause the apprehension or be aware of a risk that their actions will cause the victim to apprehend immediate unlawful force and go ahead anyway.
So they need foresight of the victim apprehending the force.
Yes. Spratt is the key case here. Remember Spratt. The defendant fired an air pistol out of a window and hit a young girl he hadn't seen. His conviction for ABH was quashed because there was no underlying assault. He didn't intend to cause fear or apply force to her, and crucially, he didn't foresee that anyone would apprehend force because he didn't know she was there. You need that foresight of the apprehension.
Okay, that clarifies assault the threat. Let's move on to battery, the physical contact.
Right. Battery or assault by beating. The definition is essentially any act by which the defendant intentionally or recklessly inflicts non-consensual, unlawful force upon the victim. Repeat that. Any act intentionally or recklessly inflicts unlawful force.
So the actus reus is the application of unlawful force. How much force is needed? Does it have to be violent, hurtful?
No, not at all. That's a common misconception. It's any unwanted physical contact or interference. Doesn't need to cause harm. Just making physical contact the victim hasn't agreed to.
So the examples the source gives, restraining someone, that counts.
Yes. Collins v. Wilcock. Digging someone in the ribs. Spitting Commonwealth v. Cohen showed spitting as force. Cutting someone's hair without consent. DPP v. Smith, remember that one for hair cutting? Even cutting or touching someone's clothes while they're wearing them. Day. All applications of force.
So it's really about the unwanted touching, though the source notes drugging or poisoning isn't battery.
Correct. Those fall under a different section, Section 23 of the OAPA 1861, administering noxious substances. Battery generally requires an act, too, not usually an omission.
Like the tree surgeon example, failing to remove a branch isn't battery.
But generally not.
Right.
But there is that important exception, the continuing act doctrine from Fagan v. MPC.
Ah, yes, Fagan v. MPC. The car on the policeman's foot.
Exactly. Driving onto the foot accidentally wasn't the battery. But when he realized and deliberately failed to move the car, the court treated his failure to act as a continuation of the original act of applying force. Very important principle, Fagan. And Dunn later reaffirmed the general need for an act.
Okay, does the defendant have to physically touch the victim directly?
No, direct contact isn't necessary. Force can be applied indirectly.
Like how?
Well, Scott v. Shepard, the lit firework thrown into a market, passed along by others, finally exploding in the victim's face. The original thrower was liable for battery. Repeat Scott v. Shepard.
Wow.
Or Martin shouting, "Fire in a theater," causing a panicked crush. Battery. Repeat Martin.
Oh.
Or Mitchell pushing someone who then falls onto the victim. Battery on the victim. Repeat Mitchell.
Okay, so indirect force counts. The source mentions some debatable cases, though, like digging a pit.
Yeah, arguably, if you dig a pit and someone later falls in, you haven't directly applied force to them. But contrast that with DPPV, VK, A minor. Repeat DPP, VK, A minor. That was the acid in the hand dryer case.
Right.
The court did find battery there, seemingly viewing the force of the acid hitting the next user as being applied by the defendant who put it there. So the line can be a bit blurry.
And again, like assault, the force must be unlawful. So self-defense, lawful arrest, consent, they make the force lawful.
Correct. Kenlin v. Gardner is a good contrast. Police holding boys without proper grounds for arrest that was an unlawful application of force, an assault by the police. So the boys resisting was lawful self-defense. Repeat Kenlin v. Gardner.
Okay.
But compare that with Donnelly v. Jackman. An officer just tapped the defendant on the shoulder to stop him, a trivial, generally acceptable, lawful contact. So when the defendant punched the officer, that was battery. Repeat Donnelly v. Jackman.
And that leads into the everyday contact exception from Collins v. Wilcock.
Exactly. Collins v. Wilcock is vital here. Not every unconsented touch is battery. The law accepts the ordinary jostlings, taps, bumps of everyday life in crowded places, unless the force used is excessive or hostile in the circumstances. Repeat Collins v. Wilcock.
But the source also makes the point that the touch doesn't need to be hostile to be unlawful force if consent is absent.
That's a really important nuance. If someone clearly says, "Don't touch me," or withdraws consent, then touching them, even gently or with good intentions, is battery. The surgeon example's perfect. Performing an extra unconsented procedure, even if beneficial, is battery.
Right. Now, the mens rea for battery, intention or recklessness again?
Yes, intentional recklessness, but crucially, as to the application of unlawful physical force, the contact, not as to causing any resulting harm.
So they just need to intend the touch or see a risk of the touch, knowing it's unconsented to.
Precisely. Slingsby is the case that makes this crystal clear. Repeat Slingsby. The vigorous sexual activity led to an accidental internal injury and death.
Okay.
But there was no unlawful act for manslaughter because there was no battery. Why? Because the victim consented to the sexual contact. The defendant lacked the mens rea for battery. He didn't intend or foresee applying unlawful force because the force applied was consented to.
So the mens rea focuses entirely on the unconsented to contact itself. So thinking practically then, the CPS charging standards, they often suggest charging common assault even if there are minor injuries, like bruises or maybe a chipped tooth.
Yes, the guidelines often put minor injuries like small cuts, abrasions, swellings, maybe even a broken nose or lost tooth, black eyes, into the common assault category for charging purposes.
Even though technically ABH might have occurred.
Potentially, yes. More serious injuries would usually push it up to S.47 ADH or S.20 GBH. But prosecutors have discretion, guided by those standards. It might be about proportionality, evidence, or just the practicalities of the court system. The standards aren't binding law, but they're very influential.
Okay, that makes sense. So common assault and battery, they're the foundation. Now let's climb that OAPA 1861 ladder you mentioned.
Right, the Offenses Against the Person Act, 1861. This is where we get into the more serious crimes of violence where proving harm is key. The main steps are Section 47, assault occasioning actual bodily harm, ABH. Then Section 20, malicious wounding or infliction of grievous bodily harm, GBH. And at the top, Section 18, wounding or causing GBH with intent.
Let's start with S.47, assault occasioning actual bodily harm, ABH.
Okay, to get a conviction under Section 47, the prosecution needs to prove three things. Remember these. First, a common assault that's either an assault threat or battery force. Second, that actual bodily harm occurred. And third, a causal link that the common assault occasioned the ABH. Repeat, common assault plus ABH plus causation.
So the starting point is always that threat or unlawful contact we just discussed.
Ways. The actus reus includes that initial common assault. Think back to those illustrations. Punching someone, breaking their nose, battery plus ABH. Savage throwing beer, but the glass slips and cuts, battery plus ABH. Repeat savage. Roberts unwelcome assault. Victim jumps from car in fear, breaks leg, assault plus ABH. Repeat Roberts.
So any common assault can ground a S.47 charge if ABH results. What exactly counts as actual bodily harm?
The classic definition is from Donovan. Repeat Donovan. It's any hurt or injury calculated to interfere with the health or comfort must be more than merely transient and trifling. Basically, any injury that's not insignificant, juries decide based on the facts.
Transient and trifling, so more than just a fleeting sting or a tiny scratch.
Generally, yes. Practice and CPS guidelines suggest it's injuries beyond the very minor. But interestingly, it doesn't have to be an injury to living tissue. Remember DPP v. Smith.
A ponytail cutting case.
Exactly. Repeat BPP v. Smith. Cutting off hair was ABH because it interfered with health and comfort in a way that wasn't transient or trifling. Hair is attached to the body.
And it includes psychiatric injury, too.
Yes, but it must be a recognized psychiatric illness, not just fear, distress, or panic on its own. Chan-Fook established that. Repeat Chan-Fook.
And Ireland and Burstow confirm this applies.
Yes, Ireland and Burstow are key. They confirm that psychiatric illnesses like severe depression or anxiety disorders caused by things like stalking or harassment can count as bodily harm for both S.47 and .20. Repeat Ireland and Burstow.
So Ireland is authority for 2 points. A silent phone call can be an assault. A&D, psychiatric injury resulting from an assault, can be ABH under S.47.
Precisely. A very important case, Ireland.
Okay, the third element for S.47, occasioning. That just means causing, right?
Yes, standard causation rules apply. Was the common assault a factual cause? But for test. And was it a legal cause, a substantial and operating cause, with no intervening act breaking the chain? You need to recall those principles from causation.
And Roberts is the case on causation here, too, where the victim jumped from the car.
Yes, Roberts again. Her jumping was seen as a foreseeable reaction to the assault, not something so daft or unexpected as to break the causal chain between the defendant's actions and her injury. That principle was approved in Savage. Repeat Roberts and Savage.
Now, the mens rea for S.47, this is absolutely critical, isn't it?
Hugely important. Repeat this. The mens rea for S.47 requires only the mens rea for the underlying common assault. That means intention or recklessness as to the apprehension of force for assault or the application of force for battery.
So you don't need to prove the defendant intended or foresaw the ABH itself?
Correct. Absolutely not necessary. That's the key takeaway. Remember Roberts, D didn't need to foresee the jump or injury, just have the mens rea for the initial assaultive touch threat.
And Savage didn't need to foresee the glass slipping and cutting, just have the mens rea for throwing the beer. Battery.
Exactly. So culpability rests on the foresight for the initial assault, while causation connects that assault to the resulting possibly unforeseen ABH. Remember that distinction. Proving culpability needs foresight for the assault. Proving cause does not for the ABH.
Okay, that's S.47 ABH. Moving up again to Section 20. Malicious wounding or infliction of GBH.
Right. The offense here is unlawfully and maliciously wound or inflict any grievous bodily harm. Repeat that. Unlawfully and maliciously wound or inflict GBH. Notice the or.
So two alternative ways to commit the actus reus. Wounding or inflicting GBH.
Yes. Two distinct alternatives. Repeat that. Wounding or inflicting GBH. And crucially, they are not the same thing. You can wound someone without it being GBH, or you can cause GBH without actually wounding them. Repeat that distinction.
Can you give those illustrations again?
Sure. A deep knife cut might penetrate both skin layers. That's a wound, even if it's not really serious harm overall. Conversely, hitting someone with an iron bar might fracture their skull, clearly GBH, but if the skin isn't broken, there's no wound.
Got it. So let's define wounding again clearly.
A wound requires a break in the continuity of both layers of the skin. Remember, both the dermis and the epidermis. It has to be more than just a surface scratch or graze, even if blood is drawn. Internal ruptures, like burst blood vessels causing bruises, are not wounds. That was McLaughlin. Repeat McLaughlin.
And Eisenhower is the case showing what isn't a wound.
Exactly. Repeat Eisenhower. The airgun pellet hit the eye, caused bruising, internal bleeding in the eye, but the surface, the continuity of the skin, wasn't broken, so not a wound. And the injury wasn't deemed serious enough for GBH either. Should have been charged as S.47 ABH.
But there's that exception for internal membranes.
Yes, the lining of the mouth or urethra, for example. If that's broken, it can count as a wound that was Waltham. Repeat the Waltham exception.
Okay, that's wounding. What about grievous bodily harm, GBH?
The definition comes from DPC v. Smith. Really serious bodily harm or injury. Repeat DPP v. Smith.
Really serious harm.
Yes. Janjua confirmed that just saying serious harm is an okay paraphrase for the jury. Repeat Janjua. Ultimately, it's a question of fact for the jury in each case.
And Balam is important here, about context.
Yes. Balam highlights that the jury should consider the victim's characteristics, their age, health, fitness, alongside the injuries themselves. What constitutes really serious harm for a baby or a frail elderly person might be different than for a fit adult. Think about a concert pianist's finger being broken, potentially GBH for them. Repeat Balam.
And CPS guidance gives examples like broken limbs, permanent disfigurement, loss of consciousness, needing surgery.
Yes, those sorts of injuries typically fall under GBH. And remember, it now clearly includes the transmission of serious STDs like HIV, that was DICA, and serious psychiatric injury, that was Burstow. Repeat DICA and Burstow for GBH.
Okay, and the GBH must be inflicted. This word caused some trouble historically.
It did. There was an old case, Clarence, that suggested inflict required some kind of assault or battery, some direct application of force. So transmitting an STD through consensual sex wasn't inflicted GBH back then. Repeat Clarence, but note it's disapproved.
But Burstow changed that for S.20 GBH.
Completely. Repeat Burstow. The House of Lords dealing with psychiatric GBH caused by stalking said there was no significant difference between inflicting GBH and causing GBH in this context. You can inflict GBH without any physical force or assault.
So inflict basically means cause for S.20 GBH.
Yes, and DICA confirmed this for HIV transmission too. It was inflicted. No requirement for the harm to be delivered via an assault. Inflict equals cause. Repeat DICA on this point.
What about inflicting by omission, possible for S.20?
The source suggests this is uncertain. While causing GBH under S.18 can be by omission, the words wound and inflict in S.20 perhaps sound more like positive actions. There isn't clear authority saying you can inflict by omission for S.20, so best be cautious there.
Right. Now, the mens rea for S.20, it's malice. What does that mean here?
Malice for S.20 means either intention or subjective recklessness. Repeat. Malice, intention, or recklessness.
Recklessness as to causing GBH.
No. This is crucial. Mowat is the key case. Repeat Mowat. Malice for S.20 means the defendant must intend or foresee the risk of causing some physical harm. Just some harm. It is not necessary that they intended or foresaw GBH or even ABH.
So just foreseeing any physical harm is enough for the mens rea S20, even if the outcome is GBH.
Exactly. Parmenter approved Moat on this. Repeat perimeter. Shaking the baby, they only needed to foresee a risk of some physical harm, not the serious injury that resulted, to be guilty under S20.
That's a really important point, differentiating the mens rea from the actus reus level of harm.
Absolutely fundamental for S20.
Okay, finally, the top rung, Section 18, wounding or causing GBH with intent.
Yes, the most serious, the offenses. Unlawfully and maliciously wound or cause any GBH with intent to do some GBH or with intent to resist or prevent lawful arrest. Repeat that definition carefully.
So the actus reus alternatives are the same as S20, wounding or causing GBH.
Yes. Same definition, same cases apply. Wounding needs that skin break. McLaughlin, Eisenhower, Waltham exception. GBH means really serious harm. TPPV Smith, Janjua, Ballum, Dika, Burstow. Repeat those key cases for AR.
But under SPEN 18, it can be causing GBH, not just inflicting. Does causing cover omissions?
Yes, causing GBH under S1NE definitely follows standard causation rules, and that can include omissions where a duty to act exists. Think back to cases like Pitwood, Level Crossing, Inston, Neglected, and Evans, drug overdose duty. So S.18 can be committed by omission. The phrase by any means whatsoever in the statute doesn't really add much beyond normal causation. Repeat causation link in omission cases.
Okay. But the massive difference between S.28 and S.18 lies in the mens rea.
Absolutely. Section 18 is a crime of specific or ulterior intent. Repeat, S.8 requires specific intent. The prosecution must prove the defendant intended to cause GBH or are intended to resist or prevent lawful arrest.
Whereas S.8 only required recklessness as to some harm.
Exactly. That's the key difference. S.18 needs proof of intent for that higher level outcome, GBH or resisting arrest. S.20 is basic intent foresight of some harm is enough. Repeat this key difference.
So if someone wounds but not seriously, for S.14 you'd need to show they intended a wound serious enough to be GBH.
Correct. Or if they did cause GBH, you need to show they intended that level of serious injury.
And juries are usually directed to consider if the defendant specifically intended GBH. Cases like Belfon and Purcell?
Yes. Typically it's about direct intent. Was it their aim or purpose? Not usually the more complex woolen direction on oblique intent. Repeat Belfon and Purcell.
And if the jury isn't convinced of the S.14 intent, but the other elements are there?
They can bring back an alternative verdict under S.20, malicious wounding or GBH. Mandair confirms this. Repeat Mandair.
The source mentions that case Banton judge telling the jury smashing a bottle in someone's face only meant intent for GBH. That sounds quite strong.
It does. Repeat Banton. It raises questions about how far judges should go in directing juries on inferring intent from particularly violent actions. Something to think about.
Okay, so that's the OAPA ladder climbed. Now let's circle back properly to consent, because its role changes depending on where we are on that ladder.
Yes, consent is really nuanced here. We established earlier that for common assault, specifically battery, the absence of consent is fundamental. It's part of the definition. If V consents to the contact, it's not battery.
Slingsby again being the perfect example. Consent to the sex meant no battery, so no unlawful act for the manslaughter charge. Repeat Slingsby.
But the crucial contrast, for crimes of violence sections 47-2018, where physical harm is caused deliberately, consent is normally not a defense. Repeat that. Normally no defense to deliberate harm.
Why? Because the harm itself is seen as unlawful.
Pretty much. Deliberately causing injury is generally seen as inherently unlawful against the public interest, as stated in Donovan. Consent doesn't make a criminal act lawful. AG's reference, Nussur 6 of 1980, is the key authority here. Repeat AG's reference, the 6 of 1980.
That was the informal street fight case.
Yes. Two people agreed to fight. One got ABH. The court said consent was no defense because it's not in the public interest for people to cause each other ABH for no good reason.
So that illustration, informal boxing, just light contact, common assault, consent is a defense.
Right.
Same informal boxing, but someone gets a broken nose, ABH. Section 47 applies, and consent is not a defense. Repeat that illustration.
Exactly. So maybe a more precise way to put it is for deliberately inflicted harm, ABH or worse, consent is ineffective unless the activity falls into a recognized category that the law considers privileged, usually because it serves some public interest.
Okay. Before we get to those exceptions, what actually counts as valid consent? Quick recap.
Well, it's a spectrum. Obviously not consent if it's obtained by force or threats. It can also be negated by deception or other pressures. Olugboja distinguished reluctant agreement, which is consent, from mere submission out of fear, which isn't. Repeat Olugboja.
It's a jury question based on common sense. Like, Kirk destitute girl submitting wasn't consent. Repeat Kirk.
And it can be express, yes, or implied, like participating in sports, or the everyday contact we mentioned earlier.
So when is consent definitely ineffective, especially where harm might occur?
Well, it's ineffective if the victim doesn't understand what they're consenting to, maybe due to age or mental capacity. Burrell v. Harmer, tattooing minors without understanding. Repeat Burrell v. Harmer.
And fraud or deception, when does that negate consent?
Generally, only if the fraud relates to the fundamental nature and quality of the act itself, or sometimes the identity of the person if identity is crucial. It's not usually enough if the deception is just about collateral details, like qualifications.
So, Bolduc v. Bird, fake medical student observing, and Richardson, struck-off dentist performing treatment, consent was still valid because the victims understood the nature of the act, examination treatment. Repeat Bolduc v. Bird and Richardson.
Right. But contrast, Mellon fake medical qualifications for Botox could vitiate consent if identity as qualified was key, and Tabassum, fake breast cancer screening. Consent was vitiated because they consented to a medical procedure but got something indecent, fundamentally different in nature and purpose. Repeat Mellon and Tabassum.
And the STD cases show an increasing focus on informed consent. Dika and Kanzani. Repeat Dika and Kanzani.
Yes. These establish that consent to intercourse is vitiated for assaults, .4720 purposes, if D knows they have an STD, V doesn't, and V isn't informed of the risk. V consents to sex, but not implicitly to the risk of serious harm.
But crucially, this doesn't vitiate consent for rape itself, because consent was given to the act of penetration.
That's the distinction the courts have drawn. Yes, repeat that crucial distinction. Vitiates consent for OAPA harm offenses, not for rape.
Okay, so consent is often ineffective for deliberate harm. What about the exceptions? The privileged activities?
Right, activities seen as being in the public interest, where consent can be effective even for deliberate harm, within limits.
First one, surgery, tattooing, body alteration?
Yes. Reasonable surgery is lawful with consent, includes necessary clinical procedures, but also cosmetic surgery, sex changes, etc., if properly performed with informed consent, Lord Templeman and Brown. Minors might need parental consent for non-clinical things, like circumcision and Ray J. Repeat Ray J.
Tattooing and piercing are generally okay, too.
Yes, considered lawful if reasonable, Brown. Wilson is interesting consensual branding on buttocks for adornment. The court saw it as analogous to tattooing. A private act law shouldn't interfere with lightly. Repeat Wilson.
But there are limits. RVBM.
Definitely. RVBM involved things like ear removal, nipple removal, tongue splitting. Even with consent, the court said this was unlawful. No public benefit, just gratuitous mutilation, going too far beyond accepted tattooing, piercing. Repeat RVBM.
Okay. What about boxing?
Boxing is a really significant, almost anomalous exception. It seems to have a special privilege. Acts intended to cause serious injury within the rules are consented to. The source rightly questions if spectator enjoyment is truly a good reason for this.
Especially compared to sadomasochism, like in Brown and Emmett.
Exactly. Consensual S&M causing ABH or GBH was held unlawful in Brown and Emmett. Yet boxing, which can involve similar or worse injuries intended within the rules, is lawful. It's a major point of tension. Repeat this key contrast.
And wrestling or martial arts, are they the same as boxing?
Probably not exceptions for deliberate injury outside the rules. The point isn't usually to cause serious harm. Consent there likely covers incidental injuries during the regulated sport.
Which brings us to consent and non-deliberate harm or harm risked in certain activities.
Right, where risk-taking is normal, like games and sports generally.
Consent is effective for injuries there.
Yes, for injuries sustained accidentally within the normal play of the game. Unless they are inflicted deliberately, outside the rules, then consent becomes ineffective again. Barnes is the key case. Repeat Barnes. Criminal courts should rarely interfere in sports. Instinctive errors or accidents are okay. Deliberately fouling to injure is not. There's an objective test. Considering the sport, the level, the act, the force, the risks normally accepted, D's state of mind.
And this applies to wrestling martial arts for those incidental injuries, too.
Yes.
What about horseplay? Like messing about?
Distinguished from fighting, just play fighting, high spirits. Consent might be a defense if injury results accidentally.
Yeah.
Jones is the case. The bumps game led to serious injuries. Repeat Jones. The court said evidence of consent or even just a genuine belief in consent could negate the mens rea for S.47.
And sexual relations, where harm isn't the goal.
Consent is effective for harms caused, incidentally, provided the harm wasn't deliberately inflicted for sexual gratification itself. That was the issue in Brown. Slingsby fits here again. Vigorous sex, accidental injury, consent meant no battery. Repeat Slingsby.
And with STDs again, if the victim is informed and consents to the risk.
Then informed consent is effective. Kanzani confirms this. If V knows D has the disease and consents to unprotected sex anyway, they consent to the risk, and D isn't liable under S.47 EVU 20 if transmission occurs. Repeat Kanzani.
Okay, wow. That's a really complex picture for consent. Essential for battery, but very limited for deliberate harm unless it's a specific public interest exception, but potentially effective for incidental harm in sports, horseplay, or sex if properly consented to or the risk is accepted.
You've summarized it well. It depends heavily on the offense level, whether harm was intended, and the context.
Right. Let's try to quickly recap the absolute key takeaway.
Okay. Two main forms. Crimes against autonomy, focus on consent, like common assault, and crimes of violence, focus on harm, like OAPA offenses.
Common assault, the threat, psychic, plus battery, the force, physical. Remember those definitions and the mens rea, intention, recklessness for apprehension or contact.
Remember, the immediacy point for assault has relaxed. Think Smith, Ireland, Constanza.
And battery doesn't need harm, just unconsented contact. Remember Fagan, continuing act and indirect force counts. Scott, Martin, Mitchell, DPPVK.
Then the OAPA ladder, S.47 ABH, S.20 malicious wounding GBH, S.11 wounding causing GBH with intent.
Remember the elements for each, actus reus and mens rea.
Crucially, remember wound, both skin layers broken McLaughlin, Eisenhower, versus GBH, really serious harm, DPPV Smith, Ballum, Dica Bursto.
And the mens rea differences are vital. S.47 needs only mens rea for the common assault, not the ABH. S.20 needs recklessness for some harm, Mawat Parmenter. S.18 needs specific intent to cause GBH or resist arrest.
And finally, consent. Essential for battery. Generally not a defense for deliberate OAPA harm, AG's Ref News 6. Unless a public interest exception applies. Surgery, tattooing body alt within limits like Wilson versus RVB and Boxy. Effective for incidental harm in sports, Barnes, horseplay Jones, sex, Slingsby, or STD risk if informed. Kanzani. Remember, Brown is key for the limits of consent to harm for sexual gratification.
Okay, that was a very deep dive indeed. We've covered a huge amount of ground there. Definitions, cases, distinctions, consent.
It is dense, absolutely.
Yeah.
But understanding these specific elements, the precise definitions, knowing the key cases like the back of your hand, it's just essential. Go back over them. Say the definitions out loud. Repeat the case names and what they stand for. Test yourself constantly.
Yeah, it's definitely an area where the law draws some very fine lines, doesn't it? Based on definitions, intent, context. It's worth spending time thinking about why the law draws those lines where it does. Do they always seem logical or consistent?
That's a great point. For example, think about that tension we discussed. Consensual boxing, where intent to injure within the rules is okay, versus consensual sadomasochism, where causing ABH or GBH, even if desired, is unlawful. Is the public interest distinction drawn there really convincing or justifiable? That's something definitely worth mulling over as you revise.
Definitely food for thought. Well, we really hope this deep dive has helped make these complex concepts clearer and perhaps a bit more memorable for your studies.
We certainly hope so.
A huge thank you again to the University of London for providing the source material that made this possible. And thanks also to Sinorbit Academy Sri Lanka for supporting this deep dive.
And yes, once again, the very best of luck to everyone facing exams on this. Keep working through it. You can definitely get there.
You've got this. Thanks for joining us on the deep dive.